Hello, I'm Veronica. Today I'll be presenting on alternative dispute approaches. Firstly, the early neutral evaluation. According to the textbook, this is experienced attorney or retired judge. They meet with the parties to evaluate summaries of both sides of cases. The neutral party is to provide an assessment of strengths and weaknesses and likely outcomes to estimate damages. The purpose of this is to minimize litigation costs and promote early resolution. This situation is great for efficiency and saving time and money. However, in such instances, there are drawbacks as the results are non binding and the neutral party's credibility may vary, and the parties may reject the results in the end. With the article that I pulled, they applied this to business disputes in a digital world, specifically to artificial intelligence. They advocated for specialized human decision makers within ENE. They found that within ENE, only 23% used it sometimes and 2% most of the time. Mediation was the most popular result in that study. The mini trial has been successfully used in cases for products, liability, patent infringement, governments, contracts, and employee grievances. The mini trial might also be used to resolve an antitrust case where the sticking point to settlement is the scope and definition of the relevant market or an unfair competition. But a case that turns solely on issues of law will better be resolved by summary judgment, where a case turns on the credibility of the witnesses. The mini trial will probably not be effective in this instance. With the article I pulled, they mentioned that this was good for liability, patent infringement, and government contracts and employee grievances. For summary jury trial, this is a mock trial that is non-binding and advisory, with attorneys presenting brief arguments and evidence for juries to present verdict and parties to guide settlement. It has the strengths of external perspectives. However, it does, and it exposes different risks. However, the weaknesses is that it does consume a lot of time and resources and can evoke an emotional response, which isn't always reliable. With the article that I pulled, they didn't suggest it and listed that it was a very costly alternative and there were better options. Lastly, the Dispute Resolution Board. This is a group of neutral experts assigned to a project at the beginning. They're assigned and picked intentionally to regularly assess the project progress. And when a dispute arises, the board can issue recommendations. This approach strengths is that it is preventative. It creates a lot of relationship building and keeps the project on time with this perspective. The weaknesses is that it is costly and may not address disputes when they happen to be more intense than usual. With the article I pulled, it did mention that the DRBs are usually used on large contracts in excess of $10 million. And this is because the DRBs require a lot of initial startup costs with the professionals involved and to compensate them for those regular attended meetings. But the DRBs are a foundational partnership within the projects, and building this team is crucial in determining who will be making those fair and balanced decisions. The news article I pulled was titled Harvey Peace Institute Utah Dispute Resolution and Disagree Better Launch Mediation Partnership. I thought this was really important in regards to the Dispute Resolution Board. They initiated and announced a new course within their university that focused on constructive conflict engagement through transformative mediation. Uh, this article reiterated the importance of preserving relationships through the business process. And personally, I see the benefit of the public private partnerships as they're essential in obtaining funding and sharing resources within our communities. It's essential to build these relationships for successful projects as they do necessitate cooperation, understanding, and empathy. Thank you so much.